Okay, who is ready to have their mind blown? This scenario is going to wreck your brain because it wrecked mine, and I need to now wreck everyone else's brains. Okay, so here's a scenario that just happened, and it proves my point of when I tell clients, hey, now that we're creating this trust for you, you need to have the conversation with your children and make sure they're also creating a trust right now as well. So that way, whenever you die, whatever they inherit from you can be protected and not go through probate. Keep that in mind with what I'm about to tell you. So, buckle up. Okay. I have a woman who called. She says, I'm the successor trustee of my mother-in-law's trust. And she goes, well, actually, me and my husband were successor trustees of my mother-in-law's trust. Okay, give me more details. My mother-in-law died. Okay, when she died? 8 months ago. Okay, got it. So you and your husband are co-trustees of his mother's trust. She goes, well, yes, but my husband also died. And I'm like, oh, okay. All right, so let me figure this out. All right, I'm like, all right, I gotta get my thinking cap on. Okay, so you and your husband are co-trustees of this trust. And he's also died. When did he die? A couple months ago, 1 or 2 months ago, she said. Okay, great. Let me figure that out. So you're the surviving trustee. She goes, yes. Okay. Who are the beneficiaries of the trust? And she goes, well, I'm the beneficiary. And I go, so you were named like as the first beneficiary. And she goes, well, no, my husband was the beneficiary. Oh, okay. I kind of already knew where this was going. So your husband was a beneficiary of the trust. And when his mom died, you did not administer the trust, meaning you didn't remove any property from the trust. You didn't do an affidavit of death. He didn't deed the home to himself. Did he create a trust? Did he create a will? Did he do any kind of planning? No. No administration occurred when his mom died. No deed transfers, and he also didn't do any planning. Now he is also dead. Okay. Did the mom have any other children, or was this just her only kid? No, she actually had 5 children total, him included, and she was disinheriting all 4 of them. So this is the way the plan worked. Mother-in-law created a trust. Mother-in-law left her one son as the beneficiary, but the son and his wife as co-trustees, meaning the people to administer the estate. And then made her the son's wife, an alternate beneficiary. So the wife, which is understandable, she thought, well, now that my husband is deceased, I'm just the beneficiary. I'm the trustee. I'm the beneficiary. I'm just going to have everything deeded over to me because we live in the home. That's why she left it to us, anyways. But the thing is, the mother-in-law did not leave the home to both of them. She left the home to her son. The problem is that when mother-in-law died, that trust vested in her son, meaning the son was now the owner. That was his home. Just because he didn't administer and he didn't take it didn't mean it didn't belong to him. Now, alternate beneficiaries only come in if they predecease. So if the husband had died first and then the mother-in-law, yes, my client would be the alternate beneficiary because it would have automatically skipped over her husband since he wasn't alive, so he couldn't get it. The thing is, he was alive when his mom died. So now I get the joy of explaining it to her that not only is she still the trustee of this trust, she's also got to open up a probate for her own husband. And guess what? Inheritances are separate property, meaning she can't claim, well, I'm his wife, I get it, because he didn't do a trust either. See, if he had created a trust, he could have had his wife be the beneficiary of that trust, and we could submit that to probate to say, hey, I'm the wife, and he did want me to have whatever he got. Now that doesn't work. So if you're not tracking, this means she gets to not only administer her mother-in-law's trust, but she doesn't get to inherit from her mother-in-law's trust. Because what happened is her husband, her deceased husband's estate, is inheriting from his mother's trust. And now wife gets to open up probate for her husband. she cannot have the whole estate because inheritances are separate property. Meaning we can claim, as a spouse that she's entitled to something. She may very well get half of the estate. But now those 4 other siblings that mother disinherited, they get to inherit. You want to know why? They're not inheriting from the mother's trust. They're inheriting from their deceased brother's estate because my client and her husband, they did not have children. So now when wife brings the trust and probate and all that stuff, and she opens everything up and they do a probate of her husband's estate, they need to look for his next of kin. His next of kin are his siblings. And so wife, at best case scenario, is only going to get half. The other half is going to go 4 ways to the siblings that would have never received anything from their mother's estate. But now, kind of like a back door, they're still getting from the estate. It is a complete nightmare. Like, it probably took me 30 minutes to wrap my brain around this. But it brings me back to why I meet with my clients and I tell them, your trust protects you. That's it. So like when you die, if your kids need their own plans. If this son and, slash husband, right, had created a trust that said my wife gets everything, then in the probate through a pour over will, we could get all of these assets that would have gone to his estate to his wife. But now she's missing out on it. And the part that's really concerning is husband and wife lived in that home. So it's very possible that she will be out of the home. Planning is really important, but conversations are important and setting expectations are important. And people need to understand that when they create a trust, their beneficiaries are going to get something. They're going to inherit something, but they need to protect that inheritance, because if they don't protect what they're receiving and they die, it still ends up back in probate. And so this is just, honestly, it's really sad. I feel super bad for her. There's not much that I can do. Like, I can't make this all go away. The husband should have had a trust or even a will. If you follow me, you know I'm against wills, but a will could have at least forced this asset back to her. Yes, there would have been a probate. Yes, there would have been costs. Yes, we try to avoid all of that. But in this one circumstance, it would have at least got the property back to her instead of being split with his siblings. So it's important to understand planning, but it's important to have an attorney that doesn't just dismiss you. Well, here's your plan, and doesn't tell you anything. I tell my clients different scenarios, and I also tell them, now bring in your kids, bring in your family. You have to understand that everybody needs their own setup. So really, really important. If you have created a trust, but your kids are inheriting from you and they're 18 or older, and they don't have anything in order, they still need something. Because if they die right after you and no administration occurs, that could actually end up in probate because it won't go to the alternates in your trust. Alternates are only for when they predecease you or die with you, because they never could inherit because they don't exist at the time of your passing. Anybody that exists at your time of passing, it automatically belongs to them. If they die after, it goes to probate because they had to protect it themselves. Really, really important. I know this is a complicated scenario, but this is real life. This literally happened this week. So please, please do proper planning.